Hello, my name is Stephen Labiak, and welcome to Week 10 about things about bankruptcy. Today we're going to talk about lawsuits in bankruptcy. When you have a lawsuit, when it concerns bankruptcy, the date that's important is the date of the incident, the date of the tort, the date of the breach of contract. It's not the date you file the lawsuit, it's the date is what we like to call the cause of action happened. Bankruptcy, there's a very bright line. Does the cause of action occur before you filed bankruptcy, or does the cause of action happen after you filed bankruptcy? Cause of action happens after you file bankruptcy. Guess what? That cause of action is not involved in your bankruptcy. It really doesn't matter whether you owe money or you can recover money. However, if the cause of action occurs before the bankruptcy, whether it's 1 day, 1 year, or 10 years, it can potentially be involved in the bankruptcy. Now, what does that mean? Well, if it's a cause of action where you're at fault and you may owe money, you bankrupt that debt. Most cause of action of bankruptcy, there are some exceptions. You know, if you intentionally hit somebody, you beat somebody up, you involved in a drunk driving incident, those debts are typically not dischargeable. Another common one is fraud. If you commit fraud on someone, that is not a dischargeable debt in bankruptcy. The more common case, though, is where you are actually the beneficiary of a lawsuit. You've been in a car accident, slip and fall, and you have maybe a medical malpractice, and you have a potential claim against someone to be paying you money. If this happens before the bankruptcy, the most important thing is to let your bankruptcy professional know. You think you're going to keep it a secret, not tell them, and not have to worry about it, or you don't think it's important? That is not true. You're going to testify in court that you have no causes of action or potential lawsuits against people. I recently was counseling another attorney on one of this had happened. They did not disclose it to their bankruptcy person. They said twice in court that they didn't have any causes of action, any court action against anybody. And it was discovered, this, to the trustee, and now almost a year later, the bankruptcy trustee's back involved in their case, and it's just creating headaches for everybody. Versus if they'd have told their attorney up front, I think this could have been a lot smoother resolution to this case. So, but you have an injury and you have a potential claim, so what you do? First of all, you tell somebody. Tell your attorney. Then they'll be able to counsel you on what you can keep. What that means is if you have a potential $1 million lawsuit and you're going to file bankruptcy so you don't have to pay off $100,000 in debts, guess what? That ain't going to happen. You can still file bankruptcy, but if you collect $1 million, even if it's 3 years after your bankruptcy is finished, if that cause of action happened before you filed bankruptcy, you're going to have to pay that money to the trustee so they can settle out your debts. Let's say if it's a smaller typical lawsuit, maybe it's only $50,000. Well, a couple things to remember. First, your bankruptcy professional can protect part of the recovery. Your exemption schedule comes into play, so if you think you're going to collect maybe after fees and done or $20,000, you're probably going to keep the entire $20,000. In specialized cases, depending upon the type of injury, maybe you can keep up to $50,000. But typically what's going to happen if there's a case, the trustee is going to be involved. So what that means is if there's a settlement offer in the case, the trustee gets a vote because the trustee basically owns your portion of the lawsuit. So that means if you want 100 and the trustee thinks it's only worth 50 and they don't want to go to trial, the trustee is going to win on that and it's just going to be the $50,000. So that's why it's important to tell your attorney, let them know that you have this lawsuit so you can be upfront, decide whether you should file bankruptcy at that point or not, or if you do file bankruptcy, what's going to be the outcome and the consequences. The other reasons you need to disclose is it's potentially going to cause only more problems if later discovered. You're going to be committing perjury in court by not disclosing it. And it's okay in life to make mistakes. Courts are understanding if you forgot to disclose something but you later told them. And it's okay to do it that way if you forget to tell your attorney to admit it in court. But if you don't disclose it in court, you don't disclose it to the attorney, and later someone finds out, then the trustee and the courts are a lot less willing to work with you. They're going to say, this person was a bad actor. They were trying to hide this. And when somebody's trying to hide something, it becomes a little more as we have to show what happens when people don't follow the rules, when they don't try to disclose things. And it becomes a lot harsher outcome. They're not going to be as willing to negotiate. Believe it or not, trustees are human. They're not looking to make it so you can't survive, you can't pay your medical bills, you can't live, but they do have to do their job. And if you make it hard for them to do their job, well, they're going to make it hard on you. So your best thing to do is when it's involving a court case, no matter which side of it you're on, let your bankruptcy professional know, and he or she can tell you what the potential outcomes are, and that way you can make an informed decision. So if you have questions about this or any other bankruptcy-related topics, feel free to give me a call at 559-274-2868. Be more than happy to talk with you about it. My name's Stephen Labiak, and tune in next week, and we'll see what I can do for you then. Thank you.